Okay, so let's get started. I'm pleased we've got a nice mix of clients, contacts and partners and some team members on the call as well. So hopefully we'll have a good discussion and have some interesting questions for Kate. I'd like to explain how it's going to work this morning. Kate's going to talk you through 3 different aspects of this topic. The first one is some health and safety considerations. Secondly, the current challenges you may be facing. And thirdly, some sort of workforce issues to try and capture everything related to COVID related as it relates to the employees. In each session, she'll give you a list of questions and then answer them all. And hopefully she'll cover most of the issues you've got sort of off the bat. If there's anything you want to ask at the end of each session, then either you can ask them at that point, you can drop them in the chat while Kate's talking if you remember them as she's going along, or you can email them directly to Kate afterwards. I've got a couple of questions as well to throw in with a few clients who couldn't attend today but wanted the questions answering in any event. So I'll get to those too. The plan's to try and stick to 30 to 45 minutes tops this morning, but we'll see how we go. So first of all, I'd like to introduce Kate to you. Kate's been a member of the TLD team since November 2019. She qualified as a lawyer in 1990. And as well as working for other law firms and having a variety of in-house roles, she's also been a law lecturer at Bournemouth University and has had her own specialist employment legal practice for 12 years. So currently she's working at TLD for a number of clients, her main one being Goodwood. Goodwood, given their use of workers, staff and employees, Kate's obviously got extensive first-hand experience of how to deal with the issues that your workforce is going to be facing in light of the pandemic. So over to you, Kate.
Thank you. Thanks, Kirsty. So this is a massive topic and we've only got 30 to 45 minutes tops. So what I did was I tried to think of questions that you may well have in your own minds, but if we don't have time, please feel free to email me afterwards and I'll gladly respond. So as Kirsty said, we're going to be looking at 3 this meeting is being recorded on my screen. Hopefully you didn't see that. This is divided into 3. The first is around return to work and health and safety aspects in particular. Just to recap, because things are changing very quickly. From 19th of July, as I'm sure you know, most businesses don't now need to implement social distancing. Customers and workers don't have to keep apart. Government is no longer instructing people to work from home. So employers are free to implement their return to work processes. Although the government has said that they expect and recommend a gradual return over the summer. So there are only a few restrictions remaining in place. Now that may well change, but at the moment, the restrictions, the main ones are that you need to self-isolate if you test positive for coronavirus or are in close contact with someone who tests positive until 16th August. And then after 16th August, anyone under 18 and anyone who's had 2 COVID jabs and the last one in the last 10 days, more than 10 days, they don't need to isolate anymore. And people are expected, but it's voluntary, to cover their faces in crowded indoor areas. So there are big changes from massive lockdown, everyone working from home, to this relative freedom. And I get the impression that employers are finding that it's actually moving a bit too quickly for many of their employees. So they're actually facing a new set of considerations. Physical considerations, how to maintain productivity and still ensure safe working environments, how to limit workplace exposure until the time that all the workplace is vaccinated, or certainly those who want to be, and then the employment law considerations of what they need from employees, how to achieve that and whether it's lawful. So in terms of health and safety and returning to work, now that restrictions have been lifted, what steps do you actually have to take? The starting point, as with any health and safety issue at work, is that the employers have a statutory duty to provide a safe place of work and general duties of care to anyone who might access the place of work, like customers. So the question is, how do you do that in the context of COVID? The first thing you have to do, and I'm sure every business is doing this, is carry out suitable risk assessments. And then once you've identified the risks, take all reasonably practicable steps to minimise them. It's not the same as having to eliminate them, it's just how to minimise them. And there's lots of guidance out there, specifically from the Health and Safety Executive, and you should be producing COVID-specific risk assessments. And I would advise now that these are re-looked at and re-examined in the light of the lifting of the new restrictions. Because since 19th of July, employers are now basically being advised by the government to make their own decisions. The government has taken a massive step back in terms of guidance and the rules. There used to be 14 guides and they've been reduced to 6 now, and they're sector specific. So office, factories, labs, restaurants, clubs, they all have their own sector specific guidance. So look at the sector you're in, and then I'd suggest you look at the government guidance. It's called guidance, but at the end of the day, if you're not following it and you have a difficulty or a claim, even worse, if you're not following that guidance, you're probably not going to be, you're going to be found not to have carried out that duty of care properly. So in fact, the guidance, it's definitely more cautious than the media headlines about Freedom Day would suggest. And the most of the guidance is now around keeping, how do you prevent the transmission of COVID in the workplace? So it's looking at reducing the number of people that your employees have contact with. So, for example, using fixed teams or partnering, or the horrible phrase cohorting, which you might hear more and more now, using screens and barriers to separate people from each other, using back-to-back or side-to-side working rather than face-to-face, assigning specific workstations to an individual, or if there's desk sharing, then making sure that everything is clean. So the overall gist of the guidance is that it's around ventilation, it's around transmission, and looking very much at how to minimise the risk of that. One new aspect of the guidance, which we haven't seen before, is that businesses are actually encouraged to turn people away if they're showing symptoms. And I've already spoken to an employer recently about this. Somebody turned up to work coughing quietly because no one noticed, with a sore throat, stayed all day, went home, tested positive for COVID. And obviously her co-workers were furious. The employer was pretty upset too, and they were asking what they could do about it. And in the context of the employer actually having a duty to turn away people who are showing symptoms, you might need to think about how you can manage that, either by telling your employees that they now must tell you if they have symptoms, and they must take a lateral flow test before they come to work. So that's a new consideration. So do we need to do a risk assessment even if everyone is working at home? And I'm sorry if I'm talking to people who know risk assessments backwards and forwards, but I am surprised quite often at how employers avoid, if they can, or don't want to carry out risk assessments. And just going back to the point I made earlier about COVID specific risk assessments, there is a lot of guidance out there on how to do that. If you've got everyone working at home, then yes, you carry out risk assessments and you make them home working specific. And again, there are specific home working risk assessments. If you can't find them, we'd be happy to provide them for you. So in terms of the risk assessment, you'd identify what activity at work or situation could cause transmission. Think about who could be at risk, so workers, visitors, delivery drivers, whoever you've got. Decide how likely it is that your employees would be exposed, and then identify controls to reduce the risk. So it really is as simple as that. Something that I find many employers don't actually, or are not aware of, is that it's a legal duty, and it has been for a long time, that any significant findings from risk assessments have to be written down. Obviously, if you're filling out a risk assessment, they will be. But if you've got more than 50 staff, you should be publishing the results of your risk assessment and the steps you're taking to minimise the risks. And I'm sure you've seen on many websites, shops, restaurants, etc., they are doing that. They've put lengthy web pages about the steps that they're taking to minimise transmission. That's actually a duty on them to do that. So if you've got more than 50 staff, that is something that you need to be thinking about. It's not the risk assessments themselves, it's the risks you've identified and the ways, the measures that you've identified that you can take to minimise those risks. It doesn't have to be prominent on the website, but it needs to be there. So what if an employee contracts COVID while at work? Can you be held liable? At the end of the day, yes, of course you can. If and you'll have insurance, you'll have employers' liability insurance. I've spoken to a few insurers about this, and their view is very much that it is very difficult actually for an employee to prove that that the work or the employer or their employer is liable. So they've got to prove that firstly you were negligent in some way, or one of your other employees acted negligently. And we come back to the lady who came to work coughing and spluttering and then testing positive. So if you or one of your employees has acted negligently, and if one of them is acting negligently, obviously you can be vicariously liable. They've also got to show that that negligence caused, or at least materially contributed to them contracting COVID. So that's actually very difficult because it's very hard to identify exactly where you caught COVID. And you're not going to be getting claims from people who have mild symptoms. These are much more likely to be vulnerable people. Hopefully you're aware that they're physically vulnerable, so that you will already have put measures in place to protect them specifically. But if you do get a claim, if you have followed the guidance, done your risk assessments, actually turned your mind to really considering how to keep people safe and have taken those measures that you've identified, you're very unlikely to be held liable, because it's going to be very difficult for employees to prove your negligence and that your negligence caused their COVID. So that's a bit of comfort, perhaps, but at the end of the day, I would say sorry. There you go. It comes down, I was leaning on the bar. It comes down to just taking sensible steps and doing your risk assessments. In terms of consultation, something else that I believe that many employers aren't necessarily aware of is that any step that you take that's going to affect their health and safety, you have a legal duty to actually consult with them about those changes, so any changes that are made. The government guidance is absolutely emphatic that employees have the right to be consulted on those changes. It mitigates your legal risk, obviously, but it also flushes out problems that may come up before you implement any changes. Consultation, there's no magic about it. It really could be writing by email to your employees and saying, these are the steps we're going to take. If anyone's got any concerns or comments, please let us know, and leaving a bit of time for them to do that. If you have a lot of employees, you should consider actually getting, or you may already have in place, workplace representatives. But I do find that most employers don't do that, and they don't have to do that yet. So you can go, but you should be consulting with employees individually. So you firstly would check what your existing health and safety policy says about how you're engaging with employees. And depending on what the commitments are in your policy, obviously you'd be following them. But then you can just, in normal language, tell your employees what changes you're planning to make. And I'm sure you're already, and have been for some time, in constant communication with your employees about all these changes. So consultation, yes, to the answer to that. Those are the health and safety issues that I identified as maybe needing some explanation. Are there any other issues you want to ask, or is it, Kirsty, is it okay to ask for questions now, or shall we wait?
Yeah, we can do either. So if anyone has any specific health and safety ones, we can cover those now, or we can move on to the next section. No, okay, no, that's good. So health and safety, tick. But again, let me reiterate, some people love it and some people really don't. If there's anything we can do to help on health and safety, then don't hesitate to ask. What's more interesting are the current challenges that I'm finding that lots of employers are facing at the moment around the pingdemic, vaccination, PPE, that kind of stuff. So
firstly, do we have to let an employee who has been pinged self-isolate? I think the answer is pretty obvious. Or is it? There is actually a distinction to be made between employees who've been pinged by the app and employees who've been specifically told by NHS, test and trace, to stay at home. So if an employee's been pinged by the app, legally, they don't have to self-isolate. They're just advised, so it's advisory that they do. But there's a big caveat. It would be a brave employer who forced an employee to come to work if they'd actually been pinged. You need to be very cautious about asking individuals who are self-isolating following an app notification to attend work just on the basis that there's no actual legal obligation for them to stay at home. Remembering that you've got a duty of care to all employees, and if your other employees find out that somebody's been brought to work when they've been pinged, you're going to possibly have some kind of rebellion on your hands. So the fact that it's not legally obligatory probably shouldn't be important. But in answer to, do we have to let an employee who's been pinged self-isolate, that gives some kind of distinction. If they've been told by NHS test and trace, then actually it's a legal duty on you to let them stay at home. And if you don't, you can be fined, and £1,000 is a starting point. So it's another reason to let anybody who's been pinged self-isolate is that it's very hard to make the distinction between how they were told that they need to stay at home. And it's worth remembering, obviously, that the requirement to self-isolate following close contact with a positive COVID case is going to be lifted for fully vaccinated people from the 16th of August. So the pingdemic is probably going to be short-lived, relatively anyway, but that depends on the age profile of your workforce and also their uptake of the vaccination. That's the question answered about fully vaccinated employees. Can you require employees to download the app, and can you require them to switch off the app? And these are both questions that I've been asked. It's likely to be lawful to require employees to tell you if they've received an alert from the app. I would be explicit about that in my communications with employees. So make sure that they know that they have to tell you. Most employees would be very happy to tell you because they might want to stay at home, but make sure that they know that they have to. But this hasn't been tested, obviously, but the thinking is that as the use of the app is voluntary, it's going to be very tricky and much more problematic to actually require use of the app in the first place. If you do provide a phone to employees, then yes, you can put the app on there, but requiring them to download it on their own phones is much trickier. And you have to bear in mind, not everyone has a smartphone either. If you have bring your own device policies in place, you possibly could change the policy to require them to put the app on there. But again, consult with them. Get a feeling from your employees, if this is important to you, get a feeling from them about their attitude towards it. In terms of switching off the app, yes, there are quite a few circumstances employers can legitimately ask employees to switch off the app. There's nothing that says that people have to have the app on. Again, I think it comes down to your unique risk assessment and what other safety measures are in place. But if you're confident that you have a COVID safe, or as safe as can be, environment at work, then yes, you can ask them to switch off the app. And there is guidance on this, and in certain circumstances, i.e. where they're behind a fixed screen perhaps and they're fully protected from other people, the government guidance is they should switch off the app, and that's to reduce the number of people being pinged. Hopefully that's answered that question. I have also been asked, does actually having the app make it more likely that people can claim or bring a claim that or prove rather that they contracted COVID-19 at work? And the answer to that is no. The app doesn't collect names, it doesn't collect personal information and location data. It just collects the first part of an individual's postcode, which would not be personal data because it doesn't sufficiently identify them. So in the unlikely event that any application was made to the NHS to disclose the contact data, it wouldn't be able to show that someone was infected at work, or it would be very unlikely to do that. Is there anything else on test and trace? Or perhaps, no, let me do the vaccines and PPE, and then we can move on to questions. Can you insist on employees having the vaccine? I have actually, yesterday, I spoke to a client who it was an HR manager, and the MD had told her that he and the board wanted to do this, and she was basically saying help because she instinctively and rightly knew that it would not be the right thing to do, and it's not tested yet. But the advice that I'm giving to people is you should think very, very carefully about insisting on employees having the vaccine. There's an argument, certainly, around the human rights issue, human rights aspect. I think it would be a breach of Article 8, which is the right to privacy. It's an unnecessary invasion of privacy, especially if you put other measures in place. It would be very difficult to justify. There would certainly be, potentially anyway, indirect discrimination issues. So you'd be applying a provision or a practice or a requirement on employees, some of whom may be disadvantaged more than others by that. So by that, I'm thinking of pregnant women. They're not advised to have the vaccine. People with long COVID aren't advised to have a vaccine, and it's likely that long COVID is going to be held. We haven't had this tested in case law yet, but it's likely it will be held to be a disability. So you may be discriminating indirectly against people with long COVID. Young people may not, as time goes on, this is less and less, but certainly young people may not have been able to be fully vaccinated yet because of the timing. And then you've got people who have fervently believe or in not having the vaccine, and it hasn't been tested at a high level yet, but that could potentially be a philosophical belief which is protected under the discrimination, under the Equality Act. So you need to be very, very careful about this, and certainly take advice before you do that. There have been surveys, and there's one I've got here, the British Chamber of Commerce said that 78% of employers had no plans, specifically and expressly stated they had no plans to introduce forced vaccinations, and only 5% had plans to ask customers to be vaccinated before they came in. So it's not being taken up at the moment widely, and it would be a risky, a brave employer who did that, and that's the advice I gave yesterday to this particular HR manager, and she wants something in writing to show to the board. The same thing about passports, actually, requiring passports could be indirectly discriminatory, but I think that's going to come out in case law as time goes on. Can employees refuse to work if they're worried about coming to work or worried about working with unvaccinated colleagues? There is a right for employees not to come to work under the Health and Safety at Work Act, Section 44. And that has been tested, not around working with unvaccinated colleagues, but around people really being afraid to come to work. And this was last year when COVID was at its peak. They've got to show that there is a serious and imminent risk of them being in danger. And it would be really difficult for an employee to argue that, especially if you've gone through all the processes that I mentioned earlier and you've made the workplace as safe as you can reasonably make it. And it's got to be serious and imminent, not serious or imminent. So far, the Section 44 cases have not been successful, so you can take some comfort from that. And at the end of the day, the government no longer mandates that people stay at home. They are encouraging people to come back to work. You can feel secure about putting in place policies that will require people to come back to work. But I would suggest it needs to be done on a case-by-case basis. And you're dealing with real people here. You might have situations, human situations, where people are being challenged, perhaps about not being vaccinated, bullied even. You could have people proselytizing to their colleagues around the dangers of vaccination. So it's just something to be aware of as a potentially difficult situation, but you can feel secure about requiring people to come back to work. And we are at the point now, if they refuse to do that, you can probably discipline them for not doing it. So can you make employees wear personal protective equipment and face coverings? We need to make a distinction between true PPE and face coverings. And the guidance around true PPE or excess PPE is that they should not be asked to do it. Employers should be considering putting their efforts into making the workplace safe and not requiring people to wear extra PPE, except in clinical situations or where there has actually been a confirmed case of COVID. In terms of face masks, yes, the government will certainly encouraging it on you where places are crowded. In your own offices, and my impression is that most people in their workplaces are asking people to wear face masks when they're traveling around the office, but not when they're sitting at their desk. But again, it comes down to your risk assessments and how you've assessed the risk of contamination or transmission of COVID, and whether face masks are going to make your people feel better about it, but certainly whether they really are going to make them safer. Is there anything coming out of that, or any other burning issues anyone wants to ask?
I've got a question, Kate. It came from a client who couldn't be on the call today. I just wanted me to ask this on his behalf. Do employees have the right to be notified if a colleague has suspected or is diagnosed with COVID? Is there that right for another employee to be told about it?
No, there's no specific right. You owe the infected or possibly infected employee duties of privacy, and it is a special category of personal data, sensitive personal data about their health. So that's paramount. But on the other hand, you owe your other employees duties of care to ensure their health and safety. So I'd suggest that you tell people that there has been a suspected case, but don't make any references to who it is. And you make sure that your health and safety measures that you've identified are necessary are absolutely being followed, so that the real situation is that the transmission risk is reduced. But no, you shouldn't be telling people that Joe down the road in accounts has COVID. No.
Okay. Anyone else got another question on that complete minefield?
And it will change. That's the wonderful thing about this. Really, it's common sense, isn't it? And actually caring about your employees' health and safety, and that will produce the right results usually. Okay, I'll move on to workforce challenges or workforce issues for now and the future. And obviously there are health and safety challenges, and there may well be contractual changes that you need to make to put those in place. So thinking about what those changes might be, certainly rotation of team. Oh, sorry, I keep leaning on it. I'm going to step back. So thinking about what they might be, you can, lots of people they've got teams A and B, and team A is working from home and team B is in, etc. So rotating, cohorting, again, that word. So that's to reduce the number of employees in the office at any one time. Staggered working hours to help employees who have to travel on public transport, and that is quite prevalent. So people might be allowed to come in later and maybe work later, but not in every case. Rotating working weeks. There are lots of changes that you need to make, or potentially may need to make. These are to meet the health and safety challenges. So you are likely to be justified in making these changes. You have an express duty, obviously, as I keep saying, of health and safety care towards your employees. So you would be able to justify making these changes, whether or not they should be they should be temporary. You want to wait and see, obviously. But I think your first port of call is what consultation have you already carried out with your employees? If you're already doing it, then you need to just carry that on with them and talk to them about changing contracts. You also need to look at your existing terms and conditions. There are probably, hopefully, flexibility clauses in there around hours, around temporary changes that you can enforce, even if they don't agree. But what I would always suggest to every employer who's trying to introduce some kind of change, even if it's not permanent, is to get agreement in writing. And I'm sure you'll all be used now to getting agreement in writing, for example, with the furlough agreements that you will have had to put in place. So email's fine. So yes, you can introduce contractual changes. The more extreme they are, and the less temporary they are, the more care you need to take in terms of consulting with employees, making sure those changes are reasonable, and helping them sort out any issues that those changes might give them personally. That's health and safety changes, but actually, what if work has dropped off? And this is something that most employers will have already considered to death last year, when really there was no business activity going on. But now this is a chance now to look well into the future and look at what your long-term plans are. And maybe even if work has dropped off, you will decide that actually your long-term plans include hopefully an increase, and you can weather keeping on your employees for now, even though work has dropped off, or you might take the view that you need to do something drastic. So, but what I say to every employer is, before you go down the redundancy route, which is probably well, it affects everybody negatively, there are lots of ways you can meet the challenge, especially on a temporary basis. So firstly, you can reduce headcount, you can defer any new joiners, you can think about secondment if you're in that sort of situation with another company, redeployment, retraining, early retirement. I'm sure you'll already have thought about a lot of these. Employing a temporary workforce, looking for casual or temporary workers instead of permanent ones. You can look at temporary stoppages, so sabbaticals, and lots of employers did come forth advice on sabbaticals, and now have sabbatical policies. And actually, sabbaticals I personally think are a really healthy way to keep your employee workforce motivated and engaged. They don't have to be 6 months, they can be much shorter than that, but just to give people time off who can afford it, obviously. But with a security of a job to come back to, it can be really positive. Unpaid leave, make them take holidays so you don't have a glut of holiday to pay if they do leave at the end of the year or you make them redundant. And layoffs and reducing working weeks. Now, something that is really from the 1970s and 80s and was in contracts then. Not that I was looking at contracts in the 70s and 80s, but I do know that they were in there, is short time working and layoffs. And essentially, there is a legal provision, as long as it's in a contract, to allow employers to put their employees on short time working. So that means a reduced amount of hours each week with consequential pay reduction for no more than 4 weeks consecutively, or 6 out of 13 weeks. Now, if you go over the 4 weeks or the 6 out of 13, then they can claim a redundancy payment. But no redundancy payment is claimable, or redundancy situation is claimable by an employee if you keep it to those maximum time periods. There does need to be a contractual right. So the older your contract, the more likely that there will be a short time working clause in there. And if you're changing your contracts, it might be well worth thinking about that and inserting that, just making provision in the future for you to be able to lay off people or reduce their working weeks for short periods of time. Keeping people on furlough, obviously, until September. You can keep people on furlough after that. Furlough isn't a legal concept, but it's one that has been accepted now. Obviously, Boris isn't going to help you pay the money, but you can keep people on furlough. And reducing pay, so salary sacrifice, pay freezes, reducing benefits, offer home working in exchange for a reduction in pay if you've got a workforce that are really desperate to work from home, changing pension arrangements, bonuses, tightening up expenses policies. So there are lots of ways you can look at making changes without having to make redundancy. In terms of new policies, there are actually quite a few, and you may have already, not new, right, I should be sent back to school, sorry. Not necessarily new policies, but amendments to existing policies. So I would say certainly your health and safety policy should have some kind of COVID section in it, or certainly reference to COVID risk assessment. And you will need probably to look at your written health and safety procedures as well with a COVID view. What you should be looking at your discrimination and inclusion policies if you have them, and thinking specifically about the more vulnerable parts of your workforce and how the new changes that you might be bringing into play might affect them. You might need a process for handling employee complaints and concerns about health and safety particularly. One way is to introduce forums, depending on the size of your workforce. People used to always have workplace health and safety forums, and they've definitely dropped off the radar, but they can be quite instructive and useful. Whistleblowing policies, disciplinary policies. You might want to put COVID-related issues into your list of misconduct. You don't have to, because you probably have in your misconduct and gross misconduct non-exhaustive lists, references to breaches of health and safety, but that might be worth looking at. Holiday policies, if you probably have already looked at this in the context of last year, but if not, you might want to think about whether you should be allowing people to roll over, for example, because they may have a massive holiday they've got to take this year. Testing and health screening, and some employers are looking at those kind of policies. So testing, monitoring, communicating around infection in the workplace and that kind of thing. You don't necessarily want to go down the route of forced testing. That falls into the same category as making people take vaccinations, but it's certainly something with employers with large workforces may well consider that. And certainly if you've already got drugs testing policies, then you can implement that. And I guess the big one here is a mental health policy. And mental health is a huge issue, and there's a lot of recognition, perhaps more than ever before, certainly that I've come across, about employees, the importance to productivity and the growth of the company of its employees' mental health. So particularly relating to the return to work, people with pre-existing conditions may have had them worsen, people might have suffered bereavements, people may be incredibly nervous about taking up their job again, so they might need reinduction, retraining. Think about having a specific mental health policy, not just for COVID, but this is your chance really to introduce that. Talking to people on an individual basis, obviously, if they've got concerns. Thinking about employee assistance programs, if you don't have one already, or some way to signpost employees to the resources that might be available to them, even if it's not internal. I would suggest a mental health risk assessment, and I spent a bit of time looking at what's out there on the market, and there is very little. So actually TLD has produced a mental health risk assessment and policy package, which you may be interested in. I'd challenge you to have a look out there on the internet for a decent mental health risk assessment, and I certainly wasn't able to find any. And you know, engagement. How are you going to get your teams back to work and feel part of the business again, and boost morale and get them working together again? It's a huge thing that everyone's been through, obviously. In terms of remote working, I know I'm conscious of time, so apologies, but I'm sure you'll have thought about this, and so I won't spend much time on the nuts and bolts, but by what you need to consider, I'm thinking about things, the more esoteric issues, like how do you control productivity, how do you manage time recording, how do you maintain morale, how do your managers actually manage people? remotely? How can you get that sense of team and engagement from people? How do you avoid burnout? And lots of people working from home don't have a break. They work from morning to night and then suddenly look up at 5 and realize they've been sitting all day. Health and safety issues, the risk assessment, specific remote working risk assessment that you'd need to look at, IT, connectivity, data protection. So there are an awful lot of issues to consider, and you can tie that in as well with the mental health aspects of the big change in people's lives. So that's what I'd like to say about that. Again, I am conscious of time, sorry. So if anyone's got any questions, we can probably take them now, or I can talk to you afterwards by email.
I've just got one, Kate, which I think it is quite an important one. It just relates to any changes that are made to people's terms and conditions. Should they be on a temporary or a permanent basis, or does it make any difference?
Yeah, that's very important. Actually, people talk about flexible working. So HR managers among you will know that flexible working is actually a legal construct, and it's a permanent change to somebody's T's and C's. And I've been advising employers to move away from that when they're looking at remote working. So don't make people go through the flexible working application process. And that's a process which is prescribed by law. They have to be able to do it. There are 7 or 8 statutory reasons on why or the employer can rely on to refuse it. Don't go down that route. Look at these changes. I think that's a really good point, on a temporary basis, because things are going to change. Your business is going to change. The environment's going to change. The attitude to COVID and the danger from COVID is all going to change. Not all your employees have been vaccinated. So I suggest that all these changes should be very clear that it's either on a trial basis or on a temporary basis, and that you will revisit the whole thing in X months, rather than going down a flexible working route, which is a permanent change to contract. And actually employees can only make that application once a year. This is about working with employees very much to meet the current challenge. So I would say temporary.
Kate, could I ask a follow-up there? It's Stuart here. What's a reasonable time frame, a reasonable temporary time frame? 3 months, 6 months?
Yeah, I would just say 3 months at least, because it'll take time to bed in. 6 months is good as well, because we've
24
got
months.
How many?
24 months.
Well, I think employees might ask you why, but if you can justify that, I mean, why would you have 24 months? Have you got a specific reason?
No, I'm just trying to glean how long is reasonable to not commit anything long term.
You can certainly have a 24-month. It would be a fixed time change.
But not specifically 24, but 3 months, 6 months, 9 months. That's.
I would say no less than 3 months.
Yeah.
Because we've got Christmas as well, in the middle of that. 6 months, I would say, is reasonable. I think in 6 months the world's going to look very different. I hope.
Okay, thank you.
Okay.
I have a follow-up question to that actually as well, if that's okay.
Sure.
In terms of, employees wanting to make it permanent, we've kind of discussed with our staff about doing the hybrid working. And then I think we have some people that are like, no, I actually want it to be a flexible work request because they want it to be permanent naturally, right? If they're enjoying working from home or, they want to do 3 days a week from home. I mean, we've been trying to just dodge that question, I guess, for now. Be like, oh yeah, no, we're just going to do hybrid working, excuse me, for everyone. But if we do really get pushback on no, I am trying to make a flexible work request, do we have grounds? Are there any grounds to decline that based on hey, we have 800 people. If 800 people makes a flexible work request, I simply just can't, our business just can't manage that.
Absolutely. So those statutory grounds that the government lay out for refusing a flexible working request you'd definitely be able to find a couple of them, and I think certainly the impact on fellow employees would be one of them. And I think it would be quite reasonable. But then you get into the weird situation of some people being allowed to do it on a temporary basis and others being refused their flexible working request. So I think you need to be really clear to employees why you do not wish to go down the flexible working route. But they have the right to make it. They can only make it once every 12 months, so they need to think really carefully about it. If they make it, then you will find a reason within those statutory reasons. The government made it very easy for employers to refuse flexible working requests, but they should be counselled that if it's refused, and they won't be able to enjoy the temporary and trial way of hybrid or flexible working that the rest of their colleagues might be enjoying.
Yeah, that's a fair point. Thank you for that.
Yeah. Okay. Great. Okay. Well, as I said, don't hesitate to contact me if you've got anything either around what we've spoken or anything else at all. But I hope that was useful.
That's great, Kate. Thank you. I'll make sure we circulate the presentation and Kate's details to everybody on the call afterwards.
Thank you.
Okay. Good to see you all.
Thanks, folks, for your time.
Thanks, Kate. That was really
Thanks,
good.
Kate.
Thank you.
Thank you very much.
Thank
Bye-bye.
you. Bye.